Ladies and gentlemen, I'm pleased to call to order the public hearing to be held on licensing regulations. We're at the Convention Center Friday, December 13th at 9:30 a.m. or so. And we only have one item on the agenda, which is the conversations about the licensing regulations. And we will start with our own staff and its report and presentation. Executive Director Day, please begin.
Thank you, Mr. Chairman, Commissioners. Good morning.
Good morning.
First, as we start into this set of regulations, I would like to just take a minute and acknowledge Director Acosta and his team, and Deputy Counsel Grossman and his team, and Jill Griffin as well, who did a lot of outreach for us on this set of regulations so we could bring them to you today. As we move forward with our discussion, though, I just want to take a couple of minutes and emphasize a few points that may clarify areas that have significantly changed since our first draft or have been subject of some misunderstanding. First is we are not generally proposing to license or register employees that do not work in the gaming establishment. Examples would be employees of the construction firms building the facility, employees of the vendors that supply services to the gaming establishment like linen and food products. As we've continued our discussions and outreach, it seems like there's been some confusion regarding exactly who and how far our reach is in the licensing and registration. The vendors, though, of course, non-gaming vendors, will be registered as non-gaming vendors, but their employees would not be registered and licensed. There are exceptions, of course, like many things in government. There are always some but ifs. There are exceptions which would include services like installation and maintenance of gaming equipment on site. Obviously, we'll want to have that personnel registered and have the vendors, of course, will be licensed. We're also, it's important to clarify that we're proposing regulations that implement the licensing and registration of all employees of a gaming licensee and all employees in a gaming establishment. So there's been a little exchange of information back and forth on which model, which state, and actually the Massachusetts law, 23K, section 30A and C, describes particularly how that's going to occur. And it does refer to all employees in a gaming establishment, working in a gaming establishment. So we think that is an important clarification as we start, because it helps us, anybody who wants to frame their comments. We are also proposing two significant changes that directly relate to comments and suggestions received by the Commission. One is regarding subcontractors of a vendor. They would not be required to be licensed or registered. The idea here is instead the vendor, of course, will need to include required information about its subcontractors in its application. That information that's in the application with the vendor will be part of their investigation relative to their qualification to do business. Our investigation of the vendor then would include, and the vendor would also be responsible for the cost relative to those subcontractors. That will give us a discretion to look in particular about who those subcontractors might be, as the vendor is required to submit the information we would need. Of course, though, no fee would be charged to the vendor themselves. The other significant change is we've established proposed to establish a second level of gaming vendor that requires a lower initial fee and less paperwork and less investigation than the gaming vendor primary. So we think that will also provide some flexibility in the regulations and with those that want to get involved in supplying the gaming establishments. The statute itself also seems to have some confusing language concerning how we receive, process, investigate, and issue licenses and registrations. So to reconcile the statute, we are proposing to insert the Commission's Division of Licensing in the process, and we think that will be helpful. From here, Todd will lead our discussion and focus on major changes or areas that we have previously discussed, and then the three of us will do our best to answer any questions that you might have as we go on through the discussion. With that, if there's no questions of me, I'll refer to Todd.
Thank you. Good morning.
Good morning.
In addition to the individuals Mr. Day mentioned, I'd also like to just acknowledge that we received a great deal of input from our gaming consultants at both Spectrum Gaming and Michael and Carol. We're fortunate to have Mr. Michael and Mr. Carol here this morning to offer any further guidance as we go through the discussion here this morning. and from our legal consultants, I should add, at Anderson and Krieger. So we can just take it right from the top, and I think there are a couple of key principles, and some of them Rick just mentioned, that we used to help bring us to this point. And the first was that we needed to make sure that we recognized and implemented all of the provisions of the general laws that apply to the licensure and registration of employees and vendors. Those are largely contained in sections 30 and 31 of Chapter 23K, as well as in Section 12 and 16. And secondly, after conversations we had with a number of stakeholders, we felt like it was important to ensure that we strike a balance between attempting to ensure that no unsuitable individuals were able to become part of the process, but at the same time making sure that we don't create any unnecessary barriers to deserving individuals from being able to become part of the process. So with that, we've created what you have before you here today, and we think it does a pretty good job, or a good job, I should say, of achieving that. So with that backdrop, we can just start at the beginning. And the first note I would just make is relative to key gaming employees, where we start. The first thing we did was we renamed the two types of key gaming employees where there was some confusion. And we named them Key Gaming Employee Executive and Key Gaming Employee Standard. And the significance of that essentially is just the level or the process for approval that the applications would go through. The executive arm would have to come before the commission ultimately after a full investigation by the IEB and the Division of Licensing prior to having a license issued. The standard version would be able to be issued by the Division of Licensing after an investigation and approval by the IEB. So those are the two types of key gaming employee licenses that are provided for. We made a number of other adjustments to the classification of certain positions with the consultation of our gaming consultants, as well as Mr. Acosta's experience in the industry as well. And I should add Mr. Day's experience in the industry as well. Then we move on to gaming employee licensees, same type situation. There's just one area of note that we'd like to make with reference to the gaming employee licensees, and that is that it captures, and this is, I should also note, I'm sorry I didn't cover this at the beginning, that we carefully considered all of the written comments we've received to date relative to these regulations, and incorporated where we thought possible and where we thought advisable those recommendations into this draft. So on top of the consultants and what have you, we also, of course, made note and listened to the written comments from the members of the public and the stakeholders. And one of the areas that was referenced and that we incorporated here into the regulations is in the arena of gaming employee licensees. Ordinarily, those licenses would go to individuals who are employed essentially by the gaming establishment. And that is true except for three exceptions. And one pertains to individuals who are directly connected to the operation and maintenance of slot machines or other games taking place in the gaming establishment. So individuals who come in to repair slot machines or what have you are employed by vendors who generally wouldn't require to be licensed as a gaming employee. But in this respect, the regulations provide for, subject to your approval of course, that those individuals of the vendor who perform those services would have to be licensed as a gaming employee. And that was actually at the recommendation of the commenter. The second area includes surveillance personnel, same type issue. Those would be employees of a vendor who would, though, come into the gaming establishment to work on the surveillance equipment or even work on it remotely electronically. So even though those wouldn't be employees of the gaming establishment, the individuals who work for the vendor who perform that function would have to be licensed as a gaming employee. And the third category in that section applies to junket representatives. So employees of the junket enterprise who work as junket representatives, even though they wouldn't be employed by the gaming establishment, would have to be licensed as gaming employees. So those are the three exceptions we've called out in the gaming employee section.
Just explain that third category again. The junket, somebody related to junket operators.
Sure. We have not fully culled out or set out regulations governing junkets yet. There is a general law that governs junkets generally, and in the next phase we'll break that up even further. But what we do know is that there are two categories essentially of entities and individuals that will have to be licensed by the commission. And they're known as junket enterprises and junket representatives. And they're called different things in different jurisdictions, but here those terms are actually used in the general laws. So a junket enterprise is essentially the entity that oversees the junket operation. They're called, what were they called in they were called?
The gaming promoter.
The gaming
in other
promoters.
places. Yep.
They're called the gaming promoters in some of the reports you've read recently. Here they're called junket enterprises. And so that's not necessarily, it could be an individual, but it doesn't have to be. It's the entity that oversees it. The individuals who work as the representatives are known as junket representatives. And those folks could either be employed by the casino or they could be employed by the junket enterprise. And what we are saying here is that regardless of whether they're employed by the casino or the junket enterprise, that they would have to be licensed as a gaming employee. That is, that we would know who they are and what their background is. And that's the significance of that. So that is an exception to the general rule that we're only licensing individuals who are employed by the casino or the gaming establishment.
Okay, that's helpful, thank you.
On the next page, page 4, we get into gaming service employees, and there's just a quick distinction I would make there from the previous version. After careful review of the statute, we recognize that the law requires that all individuals who are employed in the gaming establishment be registered as a gaming service employee. So what that means is that even individuals who aren't employed directly by the gaming establishment, but who are employed in the gaming establishment, would need to be registered as a gaming service employee. And for example, what that means is if there is a restaurant that is leasing space at a gaming establishment, the restaurant would be a vendor. All of the employees of the restaurant would be employees of the vendor. So typically, they wouldn't have to be licensed or registered by the commission. But here, they're working in the gaming establishment. And for that reason, under the statute, according to our read, they would have to be registered as gaming service employees. And that's an important distinction, so I wanted to bring that to your attention. We think that's what the law requires. Because initially, we had written it the other way, which would be to exempt individuals essentially who work for a vendor or employed by a vendor from having to be registered. And it actually created a little bit of a disparity between folks who would both be employed in the gaming establishment. Some would have to be registered, some wouldn't. But after we carefully looked at the statute, we saw that it appears as though they both have to be registered. And we clarified that point here. That's what the red language in 134.03 at the bottom says, just so there's no uncertainty that even employees of the vendor who work in the gaming establishment have to be registered. Still on page 4, we get into vendors, and there are two kinds of vendors. There are gaming vendors and non-gaming vendors. And there were a number of comments we received on certain types of the gaming vendors. So we took steps to try to clarify what we meant by the gaming vendor moniker. And I think the cause for some of the confusion is the fact that the statute provides for, and we referenced and reflected in the regulations, the fact that certain vendors who may be by their nature non-gaming vendors, meaning they don't engage in any provision of goods or services that relates in any way to gaming, but who do over a certain amount of business with the casino, may be designated as a gaming vendor. And in other jurisdictions, they're called other things, but the statute here in Massachusetts says that the commission may designate them as a gaming vendor. So the source of the confusion was the fact that you have individuals who aren't engaged in gaming in any way who are now going to be called gaming vendors. So in an effort to try to smooth that over, we created two categories of gaming vendors, much like we did with the key gaming employees. And we called them gaming vendor primary and gaming vendor secondary. The gaming vendors primary are your classic gaming vendors who you would think of as a gaming vendor, folks who sell, manufacture slot machines and table games and all of that type of business. The gaming vendor secondary are the individuals who become gaming vendors by virtue of the fact that they conduct over a certain threshold of business. And by statute, it's over $250,000 within a 12-month period or $100,000 in a 3-month period. And we clarified the statute in a few points. I think there's a typo in the statute that we remedy here in the regulations that the commission should be aware of. It talks about $100,000 of business within a 3-year period? So here we make it a 3-month period. It doesn't really work the other way, and we assumed it had to be a typo. So you should certainly be aware of the fact that this is not what the statute says, but this is what we're saying because it doesn't work the other way.
Keep that in mind for our legislative fixed list, right?
It's on the list.
It's on the list.
Yes. And then the other thing is we quantify it as gross sales, just so we have some way to measure what the number is. And the other important thing to point out is that it applies to that amount of sales with one gaming licensee. So if you're doing under the threshold with each of the, however many it is, 3 or 4 casinos, you won't necessarily be classified as a gaming vendor. It's only when you reach that threshold with one gaming establishment that you may be classified as a gaming vendor. And that is in order to allow the commission to monitor the flow of money that comes through a casino and ensure that we place the proper level of scrutiny on the individuals doing business with a casino. So that's what the genesis of that rule is. And we also added in here the process that the gaming vendor secondary would go through to be designated as a gaming vendor secondary. What we basically say is that they can either essentially self-designate when they're applying for licensure and say, essentially, look, we have a contract for $1 million over the course of the next year, so here's my gaming vendor secondary application. Or that through the monitoring of the contracts that the division and the Bureau will perform in regulations that we haven't yet developed, that the division will notify those what will be non-gaming vendors of their obligation to file an application to become a gaming vendor secondary. And then it gives them 45 days to either file the application, to cease the business engagement, or to seek clarification or reconsideration of the designation. So those are all new rules that we've added in there. And now one of the bigger issues that we added in here and sought to clarify based upon comments we received pertains to subcontractors. So there was a question as to whether subcontractors to a vendor, A, had to be licensed at all, and if so, what category they would fall into. And after much discussion, what we've recommended to you here and what these regulations reflect are the following. Essentially, subcontractors, and we define what a subcontractor is, do not have to be licensed or registered directly with the commission. They do, however, have to be identified by the vendor in their licensing process. And the vendor will have to provide certain information about all of the subcontractors. such that the commission will still be able to monitor and issue discretionary determinations as to the suitability, if you will, of certain subcontractors, depending upon their level of involvement with the vendor, the type of business they're engaged in, and what have you. And it's an important distinction. As I said, it gives the commission discretion, which is important here, but at the same time, it doesn't unnecessarily create a barrier to certain perhaps capable and competent subcontractors from being involved in the process. What it does do, though, is it creates a level of accountability to the vendor themselves to ensure that they are doing business with suitable individuals. And the regulations provide for the commission to take action against any vendor who is involved with any unsuitable type individuals. So that's essentially the nuts and bolts of the subcontractor plan that we've set forth for you here. And that was one that garnered a lot of attention from the stakeholders. So we thought it was important to point that out. And as we kind of go through a little further, I'd like to point out some other areas.
Could you just tease out a little bit more the considerations that went into that? That means, the effect of that is, for example, if there's a general contractor for the casino, the general contractor has to be registered or licensed. But the steel erection company doesn't, and the curtain wall company doesn't, and those contracts can be millions and millions and millions of dollars. So I just wonder if you touch on the considerations that led to this approach a little bit more.
We looked at a number of different scenarios. The one that comes up first always is the construction scenario, where you have a general contractor and then subcontractors. But there are also scenarios where you could have, and the one I keep coming back to is perhaps a wedding cake baker and a small bakery that's providing cakes to the casino, perhaps. And so the rule has to work for everybody.
Right.
It's easy to create a...
It could
Right.
it could scale, you could do it at breakpoints, it doesn't have to work for everybody.
Well, that's right, of course. And I think, though, that the rule we've created will work for everybody. And the reason it works is that all of the vendors still have to be identified. But to come back to your question, Commissioner McHugh, as to where we came up with this, part of the issue would be in determining who the subcontractors even are and how far out you go. And to some degree, we still will have that issue, and that the onus will be placed on the vendor in the first instance to tell us who the subcontractor is. But one of the problems we would have, and we'll get to this in a different section, are some of the automatic disqualifiers that the law sets forth for those who are seeking licensure or registration. And if we were to require that subcontractors be licensed or registered, if those folks have certain convictions or other issues in their past, they would be automatically disqualified from any involvement. Whereas doing it this way, it provides a level of discretion in the hands of the Bureau and the Division of Licensing and ultimately the Commission to allow certain individuals to participate in the process as a subcontractor. And when you come to the bakery situation, an individual who provides boxes for the cakes, for example, may have a very small contract with the bakery. And ultimately, the bakery's contract may be itself relatively small, comparatively speaking. But if the box manufacturer has some issues in their past or even a felony conviction within the past 4 years, they would be precluded by law from having any involvement in the process, even though they have such a small role, if they were required to be registered. Whereas here, this will provide the commission with the discretion to look at the situation and say, well, we see that this subcontractor has this issue, but they only have this $2,000 contract. They never set foot in the gaming establishment. Here's what they do. So we're aware of it, we're okay with it. And that was part of the consideration that went into taking this approach. Now, when it comes to the construction companies, the reason why I think it still works is that the general contractor will have to file an application for licensure. Based upon the value of the contract, they'll likely be the gaming vendor secondary category. So they will, as part of the application, have to file a form that we've identified in here. It's a new form that I'll point out to you in the form section, called the subcontractor, I think, identification form is what it's called, whereby they identify all the subcontractors, including the steel erection company. They identify all the players in the steel erection subcontractor. And the subcontractor provides us with any releases necessary and information about the principals so that we can conduct whatever investigation is necessary to ensure that there are no unsuitable people involved. And in a situation where you have a company that's doing multi-million dollars worth of business with the vendor, more scrutiny will likely be paid to that type of subcontractor versus the other type. But ultimately, the process is the same. And the flexibility is still built in here for the Bureau and the Division of Licensure to call upon the vendor to justify the suitability of any of its associates and subcontractors in this case. So those were essentially all of the considerations that went into it. And this is kind of a measured compromise almost between the two ways, the two polar potential approaches.
I get it, and that's very hopeful. Was any thought given to the possibility of having that regime, i.e. the discretionary regime, applied to subcontracts worth X dollars or less, and subcontracts worth X dollars or more would require closer scrutiny?
I might weigh in because, yes, we did. As you get to that process, it leads you naturally to the discussion about level.
Right.
And essentially, we decided that really wouldn't be as efficient. It wouldn't provide us particularly, as much flexibility. So we're leaning more to the concept of risk assessment. So the vendor advises us who their subcontractors are, whatever the level is, and then from there, we can investigate as we need to do to make sure the vendor is qualified themselves and they're not associating with unsuitable people. Because it could vary. You know, the level could vary with the amount of record and involvement, and rather than cut it off at some particular point, it seemed more appropriate to provide the complete information.
Yeah, I wasn't thinking of cutting it off, and maybe my question was unclear. I was thinking of having the discretionary call kick in at, hypothetically, a contract worth $5 million or less. If it's $5 million or less, then this discretionary regime that we've just outlined, that would apply. If it were more than $5 million, then suitability would have to be shown. Was that what you were talking about, Director?
I was actually talking about I think the reverse. What you're suggesting is the level would apply to those who have to be actually licensed or registered.
Right.
We did not focus on that as much, at least I'm not as aware. No, we were more concerned about the consistency with that part of the process.
Yeah, the underlying concern that I have here is whether we're opening ourselves up to claims of inconsistent application. You have 5 contracts with $10 million or more. You required suitability to be shown in connection with 3 of them, and the other 6 you said that's fine. And then we find one of the 4 unsuitable. Are we opening ourselves up to litigation about the consistent application of our processes. And it's unlikely to arise if we're talking about the box supplier for the wedding cakes, because we're likely to have a consistent application there, and the dollar amounts, we want to get those small people in and the like. Just a thought.
Well, I'm certainly sure that as far as the inconsistent process or legally, there's much more qualified people here, but I think what we were looking at is in fact, we would be handling everybody, each vendor in that process the same, requiring them to file the subcontractor information, and we would be investigating in that fashion. So every contractor, every vendor would be with us, would go through the same procedure, every subcontractor would have the same, so that would be consistent, at least from my impression.
Yeah, but how we acted on them. Did we require a proof of suitability, or did we let them slide? Okay, I've made my point. I offer it for consideration.
Well, I second the point, and I think it makes some sense. I just want to add another, I don't know whether this fits in with this or not, but I wonder whether, is there a way to either in lieu of this or in addition to this, to put some kind of accountability on the vendor? In other words, is that already done?
Yes.
Okay, so if you bring in a bad person, it's going to be your problem, as well as the bad person's problem.
So it would affect your qualification of
Correct.
business as a vendor.
Right, so you're putting the burden back on them to make sure that they have done their own due diligence.
Well, that's the focus of essentially the process, is that the accountability is on the vendor. Now, they may not be able to do the diligence that we're able to do, and that's
Right.
recognized. So we may certainly have to approach whoever and kind of
Right,
point
okay.
out certain issues.
Comparatively, the process is a lot like what the commission has experienced through the
Right.
qualifier process,
Right, okay,
the
fine.
licensing
Good, all right, that's
qualifier.
clear.
It's kind of the same thing.
Yeah, we had long discussions about this very subject yesterday, because I was uncomfortable with, or I had to understand it better, let me say, because I know about, have knowledge of issues in New Jersey where it was through subcontractors that there was a real risk, and issues around unsuitable people. So I really needed to understand the process better, and Director Acosta explained to me that he felt comfortable because of this form with all the identifiers. So we would be able to, we had the information we needed to take a quick look at all of those individuals, and then, of course, a harder look if necessary. Am I characterizing our conversation,
Yeah,
David?
that is correct. I mean, obviously, coming from New Jersey, I am aware of a number of stories with subcontractors that raise some serious eyebrows. I think this process does take those issues under consideration. I want to go back to Commissioner McHugh's point. To some degree, we did consider to a small point, consider the level of business. One of the stakeholders in their comment indicated that there be an exception, in particular to subcontractors, in the construction, pre-construction phases, because that is when you're going to have the real big, $10 million contract. Once the construction phase is completed, you're not going to have that many contracts where subcontractors will be, getting 10, 12, 13 million. In fact, they suggested language to be exempt, supply less than $8 million goods and services, or $16 million when it's combined, and that's through the construction phase. These regulations, one of the things we talked about is drafting these regulations for the long term, not just for the initial phase when you are going to have these massive contracts, because a lot of it is dealing with the construction aspect of it. And yeah, we do recognize that there are going to be some really big subcontractors that are going to get some nice piece of change. But allowing the process to identify who they are. The commission can, if they wish, they may, require these individuals to be licensed at any time, should we have concerns that we need to determine suitability for these individuals.
I know that Bob and Guy, you had a chance to weigh in. Did you have a chance to consider this change, which is gathering the information but not requiring registration for subcontractors?
Yes, we did. We're comfortable with this, this process. Again, we were just talking about the key here is the disclosure, that form that allows you to identify those who are going to be the subcontractors. And I understand Commissioner McHugh's concern about the standards that would be used in applying your discretion. But for the most part, those standards can be pretty clear. It's very hard to establish a threshold that would be efficient. For example, if, say, $5 million is the threshold, you would get an astounding amount of $4.9 million contracts that you would that would be submitted to you. So I think the discretion is a rational and a reasonable way to handle that kind of situation. And we also agree that there are going to be other contracts in large amounts, but not the number that there will be in the construction phase. And then you're going to, if you establish some kind of mandatory submission of subcontractors, you're going to be faced with situations later on in the operational phases, such as people who supply slot machines have hundreds of subcontractors for glass and for meters and for all kinds of equipment that go into the slot machine. I don't know that you want to burden yourself with all of that minutia and have to worry about whether they need licenses or don't need licenses. So we're satisfied that this kind of process both covers the area and gives you the discretion to be able to make rational determinations.
Yeah, and I just want to add to that, there will be protocols put in place within the IEB for the analysis of the information that will be supplied, so that the transparency that's going to be produced by getting that information and the cross-checking that will be done with law enforcement, we feel will be adequate to identify any unsuitable people, and particularly companies that traditionally have been involved in the type of unacceptable activities of an organized nature. And if they can be identified, they're normally tracked by law enforcement anyway, and those type of infiltrations and so forth are looked for, particularly in this industry.
Thanks. I forgot about the $4.9 million contract.
They're clever people out there.
Yes.
Go ahead.
Before we do, I just want to check, because we could establish a level if the commission felt that was significantly important, wanted us to do that. So before we get too far, I wanted to make sure we're either in agreement or not on how we want to go forward.
I am persuaded by Mr. Michael's suggestion that that would not be particularly efficient.
I would agree. Yeah, I agree. I much rather prefer the risk-based approach that preserves the discretion and allows, doesn't throw out the baby with the baby with the bathwater.
Like we did, the concept is to try to be able to balance the competing demands for flexibility on people being able to be a subcontractor and our need for information and identity of those who are involved in the project.
Yes.
I'm not sure I understand who's the baby and which is the bathwater, but whatever. I'll go along with it.
I'm not sure I understood either.
That was the cake maker,
The cake maker.
The cake maker. No, the box supplier.
the box supplier. Yeah.
Thank you.
If there,
Carry on, I'm just going to get a cup of coffee.
then we move into the gaming vendor qualifiers, where we made a few adjustments there, just to streamline that review. The next, I think, significant change from the version you saw last would be on page 9, where we talk about exemptions. And it was, And we discovered that it was important to be able to create exemptions to the requirement that certain individuals be licensed or registered as vendors, or mostly registered as non-gaming vendors. And those are the one common thread through most of these, not all of them, are that these are individuals who are otherwise licensed or registered through some other governmental entity, whether it be federal or state or local, with a handful of exceptions. So, and a number of jurisdictions have similar provisions governing exemptions. So we created on the bottom of page 9, paragraph F, which deals with exemptions to the requirement that these folks be licensed or registered as vendors. It also creates, on page 10, a means by which individuals may petition to be exempt from the registration requirement by demonstrating that their registration is not necessary to protect the public interest. Beginning on page...
Todd, quick
Yes.
question. Why do you include advertising and media services as one of those exempted categories?
This is to cover the situation in which they buy ads in a newspaper to promote some type of activity. That would not be a vendor that should be captured. You know, this is just a one-time thing for to ask the New York Times to come and register because they now are printing an ad for a particular company. I don't think that's the intent of the vendor registration process.
Okay. It might be helpful to more define that out a little bit further in this.
Well, are you talking about advertising agencies? That's what I thought you were referring to. You're not talking about people who are running ads. You're talking about advertising
Advertising and media services, so it's broad.
Television station, newspapers, anything where you're printing an ad or, not the people designing it, but the entity that is publishing it or airing it or broadcasting it. Is that right?
If you hired BBD&O to be your advertising agency, would that count as and they were going to do all your advertising, would that count as a vendor?
That would most likely be a non-gaming vendor.
Okay.
I don't think that's the type of service that's being contemplated here.
Yeah, I think maybe this could be worded
Yeah,
more
that's-
clearly,
because
but
that's-
typically this exemption is done for First Amendment reasons, that the licensing of newspapers and the licensing of television stations raises First Amendment questions, and so in other jurisdictions, that's the basis for the exemption, so.
That makes complete sense to me. I think I agree with you.
Right.
Go ahead, finish your point, yeah.
I just think we just need to, if I was sitting here and I have an advertising company, I'm thinking, oh, I can do all your mock-up and your ads and artwork, and I don't need to be registered.
That's what I
which is not
thought,
the
that's
case.
what I thought it meant.
Be worded better.
We'll fix that.
Okay. Thank you, Commissioner.
The next big section, so the first section dealt with, of course, kind of categorizing who fit into each group of license or registration. The next section deals with the forms that these groups will be required to file. So that begins on page 11, starts with the multi-jurisdictional, and there are a few points that we wanted to raise here today for you to take a look at. On page 13, for example, and this is included in a number of the forms, this is an issue that came up a week or two ago relative to whether the commission wants to ask for individuals who can attest to the person's good character and reputation. Whether we should just leave that or you'd like to remove it.
I understand from our conversation why it's helpful to leave it in there.
Why is it helpful?
Essentially, we, as we analyzed this, we thought it provides good factual information that can be followed up during the investigation. Also may provide ability for us to locate an individual if we need it. So we thought it may not be the greatest information, I think, Chairman, as you have identified, but on the other hand, it could be productive, so that's why we thought we'd just leave it in. But we can go either way as well.
I just have a personal thing, it's absurd, but, I mean, as I've seen it in all these reports, it seems preposterous, but it doesn't matter. It's fine with me.
We'll just leave it.
I was somewhat in your camp, but a thoughtful explanation.
Okay.
It shouldn't be a huge, arduous task for some of you. I mean, it might be for me, but to find three people who talk well about you, I think should
Well,
be pretty
that's-
easy to find.
yeah, I mean, that's essentially what we thought. We thought that, you know, the information should be readily provided. It may be of some use and it may be helpful, and so we thought, well, let's leave it in.
Fine.
And if they can't, that's a,
Yes, it's a big issue.
It's a big predictor.
That may be also an investigative.
Threshold question, right?
We only have two.
Can you dig up three?
So, right below that, number 24, another issue, this runs throughout the form section. The part where we ask for people to consent to inspection, searches, and seizures. There was some concern that this may be some way to require people to waive their constitutional rights as a part of the licensing process, where you really don't have any say. It's almost coercive. So we thought we would raise that issue here. We've recommended taking
Which
it
page
out.
is that?
It's page 13, number 24 on the bottom. And it's contained in a number of the forms, but that's one example.
Right under the yellow.
What's an example of how this would be used or has been?
Well, that's another good point. I don't know. I mean, at least the way the language is written in the forms, it seems as though you're waiving your constitutional rights to, you know, search and seizure protection.
Well, and from the, as I was trying to think this process through, the thing that comes to mind to me most is that as we go about our job of regulation and enforcement, we're going to want access to information to all parties involved in the gaming, right of inspection, those kind of things. But that's all, we'll be describing that in separate regulations that make sure we have that ability with any licensee. So it didn't seem that it was particularly useful here and may raise more questions than it's worth.
I fully agree with that, striking that. I mean, one can argue that you don't have, you may have a constitutional right to be free of a search, you don't have a constitutional right to be a qualifier, and you can burden the latter with the surrender of the former, but it raises too many questions and permits too many abuses, it seems to me.
Would there be a problem if the waiver was limited to the gaming establishment while you are on the gaming establishment, while you're on the gaming premises? And there's no intention to go into a person's home or to greet them on the street and go through their person. But typically, this kind of search would occur, or this requirement that they be available to be examined would be while they're on the gaming premises.
Or like if they had a locker in a dressing room?
Right.
That we'd have the right to go into their locker.
Right.
Is that done elsewhere?
In New
Yeah.
Jersey, that's the limitation of the waiver in New Jersey.
If you park your car in the casino garage on your way to work, your car is subject to it?
Well, the gaming premises isn't defined as
Oh, the gaming
expansively,
premises, the
right,
gaming premises.
not the entire gaming establishment per se, but on the gaming premises.
Usually it's like, for example, an employee removing something from the gaming floor or where they work, their workstation or something. Security sometimes will do spot checks for, could be anything from employees stealing food or chips or, a variety of different things. They have waived their right of privacy to their personal effects. And that's in addition to other security measures like people in count rooms having only clear bags
Right.
and things of that sort.
Right.
Part of the overall security protocols.
That seems to me like a reasonable
Yeah.
middle ground. Does that work for you?
It does, but this applies to all gaming vendors.
It's in a couple of the forms, the waiver.
So maybe it can be removed everywhere except for the gaming,
Floor gaming premises.
yes.
While on,
Frankly, these
while on the
people aren't
gaming
really
premises.
even on the premise for the most part. I mean, they will be for the gaming keys, but not otherwise.
So maybe that would be the only place it would be left
This is the
in.
multi-jurisdictional form here, but the other side of it is that at least my experience with our regulations, of right to inspect and those kind of things, we have full right to any area, any place within any kind of gaming establishment. So I'm not necessarily opposed, but I think the language can cause more difficulty than it can be helpful.
What language would be more difficult than helpful?
The inspection, searches, and seizures waiver that's in here.
So you're saying to take it out?
Take it out?
I
thought-
think either take it out or I guess the other side would be maybe to restrict it to some kind of a waiver portion with those employees that might be on premise. But
So a separate form or separate part of, in other words, it wouldn't be part of the disclosure form, it would be a separate form?
right, it wouldn't be part of these licensing forms.
Yeah. That might be a better way to approach it. Part of your employment contract is the waiver,
The limited way, the limited.
the limited waiver, that's
Yeah.
right, yeah.
Not all employees will have contracts, so, you know, it could go on the license form for only those employees, only those persons who would be on the game, who had access to the gaming floor, be on the gaming floor that you would have any need to examine.
Yeah,
Yeah,
but.
the waiver, we'd have to, excuse me, Commissioner, the waiver, if the waiver is for the employer to be able to inspect their employees, for example, their security
No,
department.
I understand that, yeah. But everybody who is going to have a locker is going to have an employment contract, aren't they, or are they not?
No,
No, it'd be in a manual, but that's not a contract.
Okay.
They may have a term in the manual.
that's what they put it.
Well, maybe rather than
Yeah.
right by committee, we ought to ask you to come up with
a
way
better
to-
approach,
a way
a
to do
different
this.
approach. But
A
with
way to limit the, yes,
Yeah,
we agree
that's a
with
good idea.
striking it, but let's figure out a way to come up with
Right.
the more limited
Right,
application.
Right,
Fine.
I agree.
You'll see on page 22, 23, we added a new form for the gaming vendor secondary to reflect that new categorization. On page, we did want to add the social security information. Where did we have that?
It's under subcontract.
Subcontractors.
Just subcontractors? Okay. So on page 20, on page 28 is where we include the form that the vendors will have to file, identifying the subcontractors. And it's actually very similar to the information that non-gaming vendors would have to provide. There's really, you can ignore the fact that some of it's in green, that should all be in red. The old-
Christmas.
Right, well,
Holidays.
don't ignore it.
the holidays,
Don't- Don't
right?
read into it, I guess I should say.
You need some green, some red.
We thought it was important to add a requirement that social security numbers be provided as well, so that we can adequately investigate the subcontractors.
Excuse me, there's, on page 21 and page 24, this was discussion that we had with Commissioner Stebbins yesterday. We're asking that question 23 on page 21 and question 27 on page 24 be striked. We don't believe that they are necessary. Question 23 on page 21, no, 33. And question 27 on page 24.
So with the gaming vendor primary,
So it's
we're
the
not
same one,
concerned
right?
about political contributions, is that it?
Correct. It was a discussion that we had with Commissioner Stebbins, and I think his point was well taken, and I think staff agrees with Mr. Stebbins' recommendation.
I'm sorry.
It's not necessary.
So you're suggesting taking that out?
That is correct.
They'd be violating their Fifth Amendment rights to answer these questions.
Is this about political contributions?
Yes.
By vendors? Yeah. Well, there's no prohibition against political contributions by vendors that I'm aware of, so it really is not
What?
necessary.
I know
Well,
we,
this is more about, B and C are in effect about illegal contributions, but, right.
But there are already reporting requirements, there's already
Yeah, right.
rules,
I agree.
and to put us in the middle of adding another layer of regulation on top of that, we already got enough to worry about.
Right.
yeah, it was somewhat, I've been taking the opportunity to work with Director Acosta on looking at the actual vendor application forms. And what jumped off the page to me was almost a page and a half of listing these contributions. Obviously, we did have a provision where if you were an applicant, there was a ban on making political contributions during that application period, but this would be ongoing and I don't think necessary.
I have a question on page 23, item number 21. That seemed unnecessary to me. Page 23, item 21. Partly, I'm just thinking of trying to keep these things from being too onerous for everybody, but what's the value, what's the point of that one?
We don't have the final version, so I'm
Oh,
not sure
can
what.
somebody give them a copy of the final version? Do I have to spare?
Page 23, item 21?
Yeah.
We don't see any particular value in that. I mean, it's one thing if you're the holding company of the applicant.
Right.
But if you're not, if these are other companies they have stock in that have no connection to the relationship they have to the casino, doesn't seem there's any investigative value to that.
That's what I was thinking.
Is going a little bit further up the page, number
Excuse me
15.
just one sec.
Oh, I'm sorry.
Did you guys pick that up? Did you hear what, okay.
Yeah, so just to clarify, should we remove these sections that we're talking about now?
21.
Like
Well,
21
Similar
and,
section.
21 and 33 and the numbers?
Yeah, well, I think we all agreed on that.
They're all
That
out.
was your recommendation, we agreed on that.
Okay.
I'm now raising the issue of section 21 on page 23.
Right.
And Guy and Bob said that they saw no investigative value in that.
So
So
we'll delete those on,
Yeah,
in this
okay.
four, and if we identify it.
wherever else that
wherever it is.
appears, yeah.
So all the numbers will change.
Right.
Yeah. How long about do you have to go on? We do have people here who we want to make sure we have time for them to speak.
helpful. Actually, this was really the bulk of the comments that we had. There's a few other things that we can point out. But
Well, and the commissioners may have questions, but I'm not trying to rush you. I just want to make sure that we do have people, give people a chance to speak. We've already lost one person who wanted to speak.
no, you know what? Actually, that's a lot. That's most of the
big
big
stuff- the big stuff?
change, the big stuff.
Okay.
So
Want to
there's
take
a few
break
other
and then
minor.
come back to it?
I'm sorry.
Yeah.
For some reason, we shouldn't take a break.
So, should you want to finish?
No, there's no reason.
The only, yeah, makes sense.
I think we can just finish, it won't be much longer.
All right.
If that works.
All right, so let's finish up with you guys, then we'll take a real quick break, and then we'll get speakers.
All right. I would just point out, we beefed up the reciprocity for vendors.
Page.
Page 30, a little above the middle of the page. We just attempted to clarify a little bit how the reciprocity for vendors section will work. And then on page 31, one of the only changes we really made was to clarify that all licenses and registrations, and we'll just point that out real quick, will be issued by the Division of Licensing and not by the Bureau. So the Bureau will, of course, be a critical participant in the process and do all the investigations and what have you. But instead of placing the burden on the Bureau to actually issue the licenses and the registrations, we've directed that that be done by the Division of Licensing. So to that end, there are just two places that I'd like to amend the draft here. So it's on page 31 and 32, and just to clarify that the registrations will be issued by the division and not the Bureau. I think it's just worthy of note, and I think we've had a chance to brief you all on this issue individually. On the rehabilitation provision of the statute, when certain individuals may demonstrate, I'm sorry, 34. It's on 34 for licensees and 36 for registrants. The statute, this is section 16 of chapter 23K of the general laws, sets out a mechanism by which the commission may consider the rehabilitation of certain individuals who have been convicted of certain crimes. And that's a critical component of this whole process, and we've highlighted them in here just to draw your attention to the way we've reflected it in the regulations. And we wanted to just make sure that you understood the interpretation that the staff assigned to what the statute says. And what that is that first of all, the key gaming employees are not afforded the opportunity under section 16 of the general laws, chapter 23K, to demonstrate rehabilitation for any convictions for any felonies or crimes involving fraud, perjury, or theft. And that's our reading of the law. It's also important to note here that and these are automatic disqualifiers we're talking about. The commission can always take into account any other arrests and other things and make determinations as to someone's suitability based upon a pattern of certain arrests or other court involvement, but they're not automatic disqualifiers. The key here is the automatic nature of certain convictions and the automatic disqualifying nature. And the law says, the way we read it, that if you're applying for a key gaming employee license and you have any of those convictions listed in the statute that we've recited here, you're automatically disqualified from being issued a key gaming employee license. What the law does, though, is that it allows for individuals applying for the registrations and the gaming employee license to demonstrate before the Bureau rehabilitation for those convictions, which are otherwise automatic disqualifiers. And it's also important to point out for everyone that the law and the regulations talk about convictions for these offenses, not charges, not pretrial disposition, not even what in Massachusetts we refer to as quaffs. continuations without a finding. So you have to have been convicted of these crimes for them to be automatic disqualifiers. Otherwise, we can, of course, take them into consideration. We don't ignore them, but they're not automatic disqualifiers. And the way the regulations and the process will work, based upon our reading of the statute, is that if you've been convicted of any of the automatic disqualifying offenses, you can only demonstrate rehabilitation if the offense occurred more than 10 years ago, not within the 10-year period. So if you've been convicted of a felony or a crime involving theft, embezzlement, or perjury 6 years ago or 8 years ago, then you're not allowed to come in and demonstrate rehabilitation. It's an automatic disqualifier. You'd have to wait until the 10-year period elapses, at which point you could reapply and come in and demonstrate rehabilitation before a hearing officer or before the division. So we thought it was important that the commission understands what our interpretation of the law was and is in agreement with that, because it will have perhaps broad implications.
A plea of guilty is a conviction for these purposes, right?
A plea of guilty,
That's
of
what I said.
course. Yes,
A
you
plea
did
of
say
guilty.
that. You did say that,
Right.
yes. Or it's a conviction after trial. If you go to trial and a jury or a judge find you guilty, then you're guilty. Or if you plead guilty, that's a guilty. So when we look at your record, if it has a G, then that's what we would consider. If there's anything else, with certain exceptions perhaps, then it's not a conviction. It's some other resolution of your criminal matter that we will look at. So anyway, that was what we had to say about that.
You look like you were about to say something on that.
Well, I mean, that's the reading of the statute. It's, in certain instances, it could be harsh. I mean, you have somebody who has a shoplifting 9 years ago. That's a theft offense. They would be prohibited from being a slot mechanic. You know, that is a harsh result, but if that's the statute, legislative intent, then there's really nothing else the commission could do.
And on that case in point, that is the legislative intent.
That's the way we read it. Now, again, though, that would have to be a conviction. And, you know, for someone to be convicted of shoplifting in Massachusetts, you either, most likely, there are exceptions to everything, but you either have a very lengthy record or the shoplifting was particularly egregious in some way.
Well, you'd have to shoplift a car.
Yeah.
Well, I leave the Massachusetts administration to you.
Right, okay, thank you. I may have missed something. On page 28, on the subcontractor identification form, would we not want the amount of the subcontract to be in the form?
That's a good point. We probably should
Yeah,
add that.
okay.
We'll add that.
Okay, are you done with your highlights?
Oh, okay. We'll draw your attention just to page 38 and 39 where we talk about fees. We made some adjustments there. For example, we added a gaming vendor qualifier. We added that there's no fee, that fee will be wrapped into the gaming vendor fee as part of the investigation. We added the gaming vendor secondary fee of $5,000 as opposed to the $15,000 gaming vendor primary fee. We added in a late fee of 10% if you don't file on time. And that's essentially it.
Do we talk about the length of time for the license?
Okay, so the terms is on page 39 and 40. I don't think we changed any of the terms from the last time you saw it.
My only comment about that is somebody looks at $5,000 if they're going to be a small vendor, but when you realize it's over a term of 3 years, it begins to cost itself out and not look like such a heavy burden to pay.
To that point, the fees are intended to ensure that the commission is reimbursed for the cost of any investigation, and that's why they're priced as they are.
And if I remember correctly, our prices are not at the top, are they?
No, they're not.
They're pretty much the median?
Yes, in fact, outside of one particular state, they're probably lower than most other states.
And a gaming vendor would that be your wedding cake?
No.
No, because of
Well,
volume.
gaming vendor secondary, because now we call them gaming vendor primary and gaming vendor secondary. So gaming vendor primary
Right, okay.
would be the companies that manufacture the slot machines. The wedding cake, if they sell enough wedding cakes to meet the threshold, then they would reach the
They'd be secondary.
secondary. And that'll
But
be-
if your contract for wedding cakes might be $4,000.
They need to be registered.
They're
Just registered,
registered.
okay, fine, okay.
I think those are the highlights. Well, I should add one last thing. There's the second part, which were the amendments to the existing regulations that you have before you too. They're after the green sheet in your book. Although my book has a green
We
sheet.
have the
I don't
bright
know. You have
orange
an orange
sheet.
sheet. And on page 3 there, we talk about the definition of restricted area. This is complicated, and at this point, we recognize the need to define the term. And at this point in the process, without having the rest of the regulations, the internal controls and otherwise, and even having any individuals licensed, we didn't want to set up a situation where we unnecessarily require certain people to be licensed or exempt other people unintentionally. So here, what we've done is, the reason it's important, by the way, is because the definition of the term gaming employee includes, it says essentially someone who has access to a restricted area. An employee of the gaming establishment who has access to a restricted area of a gaming establishment. So we needed to factor that in to account for the fact that that's what the statute says. And we went around in circles with this definition to try to come up with one, and I think it might be one that will require attention in the future. But at this point, the way we've written it, it will allow the commission to kind of call out those areas that we consider to be restricted when we know more about the framework of these operations.
The effect of what you've done on page 1 and 2 is to leave those 1 and 2 of this supplemental is to
Right.
leave those regulations where they are, right? Back in section 101.202.
Well, these would be deleted because we talk about them in 134.
Well, okay, I know we're running, I have some concerns about that. But we can come back to that later after people have had an opportunity to talk. Are we finished now?
Are you all finished?
Yes.
Yeah, so do we have, before we get to speakers, are there any other questions from the commissioners?
No, I want to come back to this point, but we can come back to it later.
Okay. Well, I just wanted to ask you, well, and all of you, is it whether, just sort of big picture now, stepping back, are there any issues hanging out there that we should be thinking about? Are there any, sort of cutting-edge best practices that we're not accommodating? Are there new movements that are we taking account of all the good thinking that's going on out there? Have we been as rigorous as we can be to make sure that we're not asking questions that really are just pushing paper and getting in the way of people trying to do business with? Is there anything else, if you looked at it from that standpoint, that we're being as thoughtful and innovative and appropriate?
From our point of view, I think this certainly meets the challenge that you have to establish these initial licensing requirements. As time goes on, there will be other developments that the commission, like any agency, would need to adapt to internet and those technological advancements that raise all kinds of new issues regarding, where the gaming is conducted, what's the gaming establishment, who needs to be licensed, and all of that. But since there is no internet, or there are the other kinds of gaming that might come about in the future, isn't something you have to deal with at the present time, this all seems adequate to us.
Okay. And Jill, have we, and everybody, have we thought through as carefully as we can about removing impediments to minority and other sort of utilized resources?
I think so. We brought these draft regulations out to multiple community groups and chambers of commerce, our vendor advisory group, Workforce Professionals Association that represents the career centers. So a lot of the feedback and changes that you see here were informed by remarks and comments from the community. So.
Okay, good. And the issue of the impacts of Corey credit and drug testing, and, have we modulated that as thoroughly as you think we can?
Well, the comment about the statute and kind of, I share concerns about someone who has a shoplifting conviction from 9 years ago, but but that is the statute. So,
Right.
So I think the commission has done as much as possible.
Okay. We might think of, I don't know exactly where the various lines are drawn, but that might be something that if we got, did we get pushback? Was there a lot of constructive comment that said this is onerous and what we couldn't do anything about it because of the law?
So there were some concerns about Corey check, specifically for gaming service employees. For example, employees who work in the restaurants in the gaming establishment. So I guess the interpretation of the gaming establishment, there were concerns about the licensing fee. So those are some of the concerns. I think folks were pleased that the credit check was not going to be a barrier. But I think some of the people and comments, they're here today, so you can hear directly from them.
Okay, good. Well, and on the issue of like Corey for service workers is a really good example. It may be, if that's one where the law imposes on us, then we're stuck with that. But we might want to file this away too. We will be talking someday with the legislature about whether or not there are things we want to address in the law, and that might be one we want to think about.
The other concern, which is directly in the statute, was the threshold for the secondary, what do we call it, secondary vendors? That the dollar amounts were low, but that is directly from the statute. And I think Director Acosta and others have really come up with an interesting solution, creating the secondary vendor category.
Right.
Where the licensing fee is not as onerous as,
Right.
So I think that was a really great solution based on feedback from the, I believe it was from the Minority Contractors Association. So.
Okay. Good, thank you. Anybody else? Okay.
I just have one thing I wanted to say. My clever quip about shoplifting a car, which was clever, but like many clever quips, it was wrong, and I apologize to Mr. Michael. Mr. Michael's point is exactly right. Shoplifting of any kind, and the point was just made by Director. would trigger the 10-year disqualification, and it would be, it doesn't have to be a felony theft. It's any theft, and that's something we might think about when we go back to the legislature with cures.
It's perfectly okay. In New Jersey, shoplifting of cars is not that unusual.
It's still one of the highest in the nation, yes.
I lost one, I know.
That's why they take the train up.
Okay, we have a list of people who have asked to speak. Thank you very much. I mean, this is a lot of really great work, and, you know, we appreciate it. We lost, I believe, Mr. Steve O'Neill had to leave. He was first on the list. Is he gone? Then Suni Ali from BWA in Boston. Okay. Hakeem Cunningham from the same organization? Yes, sir. Yeah, why don't you come over here? Welcome.
Welcome. Good morning.
Good morning.
Good morning. From the Mass Gaming Commission. I was actually on my way out, but I was like, you know what? This is a strong, very strong reason to stay. Once I heard a lot of what came from the left. My name is Hakeem Cunningham. I'm actually a director of labor and human rights organizing for Boston Workers Alliance. And we represent 4,000 underemployed and unemployed workers from the Boston area. We also represent a citywide neighborhood coalition that's focused on construction jobs and also permanent jobs. One of the main things is I want to talk about is economic opportunity in relation to the casino as a whole. This is such a pivotal situation right now in relation to Massachusetts and poverty and economic opportunity. I don't really think people have deeply looked at the gravity of how this can impact families who are going to be affected by the thousands of jobs created from this. This is such a magnitude that if properly understood, this casino, if done right, it can be positive impacts on thousands of families that have been waiting for some opportunity like this to come. I've listened to a lot. Some of the regulations have class discrimination. Poor people, credit checks. If you're poor, what is a credit check? Really doesn't matter. If you're surviving off of $300 a month, government assistance, what does a credit check really do for you, right? So we have to start to think critically, like you were saying earlier, about impediments to economic opportunity, where the casino can actually provide permanent jobs, construction jobs, vendor and contractor services, but also you should have human rights provisions. It should be a human right for individuals who live in the state of Massachusetts to actually to be able to be impacted in a way where what takes place at these casinos actually helps their families also. People have been waiting for casinos to come to Massachusetts, not for the fact that they want to spend their 401k, not at all. Not for the fact that they want to raid the piggy bank. They actually want a job that they can go to, they can be proud of, they can tell their children about, they can go to their wife or husband and say, hey, I got a job at the casino. I think we're gonna be okay. We can get off of the government assistance. We can get away from food stamps. We can get away from WIC, and we can get away from all these government subsidies because I've got a decent job that's gonna pay me a decent wage and it's gonna impact our family in a way where we might be able to send our first or second child to college, right? I'm pretty sure you all have children and grandchildren that you put through school, right? And now they have economic opportunities and they bring back wealth and energy and vitality to the family at holiday parties and dinners where you're like, wow, I had that job for 15 to 20 years. My child went to college. They have a bachelor's and master's degree, and they have all types of opportunities and options that were given to them by me working hard. And I think that we have to look at the family structure and how these casinos can impact families in a way where people remember that you're employing not only a person, but a person that belongs to a household. And you should look at the regulations around Corey, background checks, and everything in a way where you start to put a human rights lens to it. People have that opportunity.
I appreciate this, and I want to be sure that we're specific about the points.
Yes.
You mentioned both Corey and credit.
Yeah.
And we talked about credit. Would you just explain where does the credit check status sit for levels of employee?
Well, it may be that we will check credit histories, but it's important to understand that there is no reason to suspect that it will necessarily be any kind of disqualifier, depending upon the nature of the position you're applying for a license for. The only automatic disqualifiers are for certain crimes, and those are in the law. So it's really just a piece of the puzzle, I would submit. Corey is different. The law, I believe, requires us to check Corey. But I think it's important to understand that with the exception of the crimes that are listed in the statute, the ones I mentioned, which are felonies, crimes for embezzlement, theft, or perjury, everything else is wholly discretionary. So we have spoken to individuals who share your outlook, and I can tell you that we share that outlook, and we have looked at all these issues, and there is absolutely no intention to unnecessarily or artificially exclude individuals from this process. I think the Commission has recognized from the beginning the importance of offering opportunity to individuals who don't otherwise have it now.
We've clearly established this as the wish of the folks sitting up here, but sometimes translating the wish down to the real lives of people that are struggling to try to figure out how to get a $15 to $20 an hour job is different. And I just want to make sure that we're doing everything we can to bridge from what I think is a policy intention that you would agree with, to bridge from that to the reality of the application of the real people that a person like Mr. Cunningham works with, and figuring out how to facilitate their chance to get these jobs. And, you know, that's your job, Jill, is to make sure that bridging from our policy to the reality of the people he lives with happens. And so that's why I wanted to clarify that. Go ahead.
Thank you. I just feel like a certain population is going to be isolated altogether from the casino movement in Massachusetts. And there are thousands of people who have voiced concern over citywide meetings about, you know, immigrant population, African American minorities, people of color, who are just not going to be able to be in a position of opportunity when the casino comes to Massachusetts. So I think for us, we would ask for a little bit more deeply looked at analysis of the regulations, Corey, background checks, and just to see if that works for people who are not affected adversely from economic. Well, you know, if you're making $100,000, $200,000, $400,000 a year, you're not affected. But if you're making under $13,000 a year to survive, like, think about it, right? A person has to survive for 12 months off of less than $13,000 in America. So we need to start to look at how the Mass Gaming Commission and this casino opportunity can actually help families that are suffering in one of the richest states in the world. Let's just be honest. Massachusetts is one of the richest states in the world. You know, we have old money here. So we need to figure out how the casino can address the population issues, deal with the isolation of certain classes and races. There needs to, I understand the tiered classification process. I get it. But at the same time, you have to say to yourself, how can this help populations? And it's a good PR move, right? Mass Gaming Commission is brand new. Casinos want to come to Massachusetts. A lot of developers want to come here and build. So if you positively look at the diversity issues in relation to permanent jobs, construction jobs, and contracts, and I think you'll attract more individuals to the state of Massachusetts from saying that, yes, we do address, the diversity and people of color issue in relation to permanent jobs, construction jobs, contracts. And they're like, okay, well, Massachusetts has a good grasp on what it is for people of a, excluded population. And I'll end on the fact that everyone here is not really affected by the economic downturn that took place in 08 and 09. People are lost their homes, they've lost their will to fight. And I think that if we start to look at this casino in a way where the casino is going to be a catalyst for thousands of families to get back on the right track after being on welfare and food stamps for 3 or 4 years because they've lost jobs and they've lost the will to fight in America, I think everyone here will be in a position where they can leave feeling like they did a good thing, and people feel like the casino is a good thing. So I'll end on that note.
Okay.
Thank you.
Thank you.
Thank you very much. I appreciate your perspective. And I don't know how much of this you've already done, but I hope you can follow through with Mr. Cunningham and just to be looking for practical ways to get through this. Thank you very much.
Yeah, and we're willing, I will make sure that everyone gets my contact info because our organization is willing to work to think through these things.
Yeah.
Because I feel like if we can help from the grassroots level, then we're
That's what-
able to
that's what
have
we're
a happy
looking for.
medium.
So why don't you and Jill exchange information right now?
All right, thank you.
Thank you very much, Mr. Cunningham.
Mr. Chairman, I just wanted to point out that you mentioned a practical example,
Yep.
and I think the whole concept around the subcontractor is an example of that kind of thinking that we're trying to move
Right.
forward, because it removes some of the mandatory elements, but provides the ability for us to take a more global
Right.
look and still get the information we need
Right.
to protect the
Yeah, that's great. And I know that a lot of efforts have been made to try to deal with these kinds of issues, and we've talked about this a lot. We need to make sure that the various communities we're trying to affect know that these efforts are being made and know how it's being done, so it's got to be a lot of proactive outreach. But also, there's still, identifying the companies and the folks that might be interested and talking more and more about practical steps is worth continuing to do. But I know you've worked hard on this, but I want to keep working hard on it. Mr. Watkins from the Urban League.
He also says his regrets. He quit last minute. He got pulled to another meeting, but he's going to submit written comments.
Okay, great. Thank you. Lisa Clausen from Unite Here. Welcome.
Thank you. Good morning. Thank you for hearing from me. So my name is Lisa Clausen. I'm a resident of Dorchester, Massachusetts, and I'm a director at Unite Here, Local 26 here in Boston. I'll be offering comments today on behalf of Unite Here, and we're the largest union representing gaming service workers across the country, and I've also submitted written comments prior to the hearing. Our primary concern is that some of the proposed regulations concerning the registration and licensing of casino workers would create barriers to access for the jobs that will be created with the introduction of casinos. And a primary goal of the gaming legislation was job creation. Our union's experience representing gaming workers shows that these can be good full-time jobs, and many of the jobs do not require a high school diploma or a college degree, and provide economic opportunity, especially to communities that have experienced, as Mr. Cunningham said, high rates of unemployment and underemployment. Our concern, however, is that the registration and licensing process may prevent many people from accessing the casino jobs that will be created, and that low-income communities and communities of color will be disproportionately cut off. We're particularly concerned about the handling of query checks, and the requirement of a query check and a list of arrests and charges for all workers, especially gaming service employees, prevents a barrier to gaining access to those jobs. Even if the Commission intends to take into account rehabilitation when considering whether to register an applicant, the requirement to run a query check may cause some employers to screen job applicants and avoid hiring workers with an open query of any kind. The Query Reform Law of 2010 bans questions about criminal history from initial written job application unless the absence of a conviction is required for a particular job. Massachusetts appears to be following the model of New Jersey. However, in other long-established gaming jurisdictions, including Nevada and Mississippi, service workers are not required to be licensed or registered by the state. We understand that Massachusetts requires some form of registration for service workers, but following the Nevada or Mississippi models, we encourage the Commission to follow those and to minimize the impact of the registration requirement investigations upon service workers, and to ensure that the establishment of gaming in Massachusetts has the intended outcome of expanding economic opportunity to the unemployed and underemployed. If it is necessary to conduct some sort of query check on all workers in order to be compliant with the gaming statute, we caution the Gaming Commission that it needs to work closely with employers to ensure that they don't use query checks to screen out applicants. Without clear directions and oversight, employers are likely to avoid hiring workers with a query to avoid the uncertainty of whether the person will meet the Commission's registration requirements. There are some additional areas of concern also for us in addition to the query requirement. One is fees, and the fee of $300 for gaming employees and $75 for gaming service employees have been proposed. And these fees prevent a real barrier for people from lower income communities seeking to apply for gaming jobs, particularly for job seekers who are currently out of work. We encourage the Commission to consider whether these fees exceed the cost of licensing or registering the worker, and if that's the case, the fees should be reduced, particularly for service workers, so that the application fee does not prevent an unnecessary barrier to employment. We also can encourage the Commission to consider requiring that the employer, not the employee, pay the fee, or at least requiring employers to offer payroll deductions for those fees to allow workers to pay for the fees after they begin earning wages and to divide the payment over multiple pay periods. We're also concerned about the financial suitability. We're encouraged to see that a federal check, a credit check is not required as part of the employee licensing and registration process. However, we note that applicants must provide a list of all government financial liens or judgments, and we hope that owing money for child support or student loans will not be a barrier to working in the gaming industry. For individuals who have been unemployed or underemployed, again, a job in the gaming industry could provide stable income needed to repay back debt. We're also concerned about the definition, the draft regulations defining restricted area as part of the gaming establishment in which gaming operations are conducted. We interpret this definition to include the gaming floor containing slot machines and table games, and we believe this definition is problematic because certain service workers working on the gaming floor do not participate in or have any control over gaming operations. For example, an EVS worker, a janitor, vacuums around the slot machines. A cocktail server delivers drinks to customers playing slot machines or table games, or a bar back walks bottles of champagne or other beverages over to a VIP area. And therefore, the definition of restricted area is so broad that it would have the consequence of requiring that many service workers have to hold gaming employee licenses rather than just register. We understand the need for security in a casino. However, we also note that customers have similar access to these areas but are not licensed by the Commission. We appreciate that the Commission has taken a thoughtful approach to implementing the gaming statute. We hope that the Commission will approach the licensing and registration of workers in a manner that maximizes access to job opportunities that will be created. And we also ask that there be an opportunity, that there'll be a second hearing on this issue, perhaps in January. We have heard from different people who wanted to speak today but weren't able to on the short notice. Steve O'Neill from Epica, who had to leave early, came from Western Mass. He knew because he had to leave early there was a good chance he wouldn't have an opportunity to speak, but it was still important enough for him to make the trek out from there this morning. We believe that there are legislators and other organizations who would also be interested in speaking if they had more opportunity in which to do so. There were a lot of people at the State House who were involved in the Corey legislation of 2010 who we'd like to have an opportunity to weigh in on this. Thank you.
Thank you.
Thank you.
Go ahead.
I was going to say that your comments echo those of Mr. Cunningham, particularly with respect to the query and the credit checks. And I wonder if part of the solution, I mean, on the one hand, it'd be good to know if a housekeeper had 7 theft convictions of one kind or another. That would be a helpful kind of thing to know. On the other hand, as Mr. Grossman has said, it's not an automatic disqualifier. And I wonder if the regulations couldn't, with respect to both query and credit, have some further statement about how we're going to use that stuff. And that would be reassuring so that the minor shoplifting conviction, if we can get around the statutory barrier, is not the kind of thing that's going to be a disqualifier, and so that employers would know that, and so that prospective employees would know that. It seems to me that that's something that we can address in the regulations themselves. You've already focused on the restricted area issue, and we need to think more about that. But I think we ought to do more to restrict the Commission's discretion with respect to those kinds of things.
Well, and to restrict the hiring organization's discretion.
Yes, but I was tying the two really together.
Right.
Maybe that too. But I was thinking that if we indicated in our regulations that only serious financial problems, for example, hundreds of thousands of dollars in debt, you're not going to be employed in the counting room. Maybe you can be employed someplace else. That's just an example. If we say that in our regulations, then it seems to me the employers are given a heads up up front that if the person's otherwise desirable, that isn't going to be a barrier.
We would welcome you taking, really working on this issue and taking a look
Right.
at where there are different ways to address it. We do continue to worry that having any query requirements for service employees just means that many times employers just don't look at the nuances of what is on the query, and immediately if someone has one, they're kind of put into a different category. And as long as they have, and they will have plenty of other people who are also applying.
But we'll
they're
be
not
doing the
gonna do it.
query, right?
We do the query, and
We
I
do
think
the
the law
query.
requires us to do the query.
And the employer won't know what's on the query necessarily.
No, they'd have no
Will
reason.
they know that there is an applicant with a query versus an applicant without one?
Not necessarily, because the way the system was set up to work, we didn't actually discuss this, we should discuss this too. As part of the application, the applicant would have to get some letter or acknowledgement from the employer that if they become registered, that they will be employed. So that's still in here, and we should actually talk about that. But otherwise, the application comes to the commission. The commission will run the person's query and make a decision as to whether to issue the the registration will be issued, but whether to rescind the registration based upon a conviction. So there's no reason to suspect that the employer the employer won't have access to the query because we have restrictions placed on us as
Right.
to what we can do with
We can't disclose that information in any
So
event.
we will either revoke the registration ourselves based upon some conviction or pattern of conduct, which we can, of course, clarify how we'll go about doing that, or not. So it seems unlikely that the employer would get the information from us anyway, or through the application process as to what was on the person's query. And I welcome you to read it, and I'll be happy to go through it with you. In section 16 of the general laws, it talks about reasons why the commission must deny an application for registration of licensure, and it talks about these convictions. So of course, the only way for the commission to know whether these convictions exist is to run somebody's query.
But the bottom line is, isn't it, that the prospective employee goes to the employer. The prospective employee is interviewed by the employer who makes the decision yes or no. Then if the prospective employer makes the decision yes, then the prospective employee is sent over to the commission The commission does the background check, comes up with the information, which stays in the commission's files, and either issues the license or doesn't. So the screening out function
It's done by the
is-
commission, not the employer.
is, and
I think it would be very useful to spell out the extent of what is acceptable and what's not around quarry so that people know whether it's worth their time and energy.
right.
and
No,
which
no,
to
I
apply.
agree with that.
Totally.
And so the $75 fee, does that only happen if they've been approved by the employer to be hired and then have to have the check done?
I don't know.
Well,
Oh,
that would be
yeah.
part of the application. So they would have gone to, assuming we keep that provision in here, they would have gone to the employer. The employer sends them a letter or whatever saying, we will hire you if you get registered. And then they would have to file that letter with the filing fee and the other application materials with the commission.
So it's only if the employer's promised them a job.
But even with that, I mean, it struck me, and the thought went through my mind, I didn't say it, but I'm glad you did, that I'm not sure about the $300 and the $75. I mean, it's hard for people like us to realize that some people don't have $75.
Well,
And
Well,
if,
suppose you allowed them to pay that fee within,
yeah,
30
that's what
days.
that's what I'm saying. So, if you get the job, but even if you don't get the job, then you've paid $75 from what, and you don't have the job.
There are provisions. Director Acosta, we've
Okay.
talked about this.
There is nothing that says that the casino cannot enter into payroll deduction. There's nothing that says that the casino cannot agree to pay that fee at time of application on behalf of the individual and recoup that fee later. One of the main reasons why staff recommended to have the casino promise employment before we accept an application is to avoid a situation in which an individual files an application, pays $300, and then doesn't get a job, and then they're out of $300 when they really can't afford that. It's my experience that most casinos are much more interested in the employment and will enter into agreement that they've done it in other states with some type of payroll deduction over a period of time. I mean, that's standard practice that I don't foresee not happening here.
Well, if it's standard practice, I mean, I would say I don't see a reason why we shouldn't codify that.
Yeah.
We don't have the time to work all these things out, but I would like to see the 75 and the 300 thought through some more. Maybe it is standard practice, but we ought to say that's the standard practice we want, if we have to have it at all. And I, for one, would like to think about that a little bit. And some of these other nuances, these are, again, the kinds of things that bridge the theory to the practice. And if you could follow up maybe with Ms. Clausen on some of these issues and make sure that she's read the stuff right and that she understands really what we've said and what we're dealing with in terms of the law, but where she does, make sure that we're trying to accommodate the realities that she's raising as much as possible.
Mr. Chairman, too, I think it's important for us to note that the $75 is once every 5 years, and the 300 is once every 3 years.
I understand that, but it's still, $75 is a lot of money for some
That's
people.
that initial payment,
Right.
I'm not worried about subsequent years.
If
but
it could be taken
I
out
like the idea of codifying this someplace. It gives the employer the flexibility to do what she suggests, doing the payroll withdrawal or paying on behalf of the applicant up front.
And there's also the person that does get promised a job, does apply, puts up their money, and we don't approve them. And they're out $75 or $300. So we have to move on, but I do want to have this thought about more. I think this is really important points.
Thank you.
Thank you very much. Aaron Tanaka? Welcome.
Morning.
Good morning.
Thanks for having me here. My name is Aaron Tanaka. I'm actually the former director at the Boston Workers Alliance with Hakeem's organization. I was also the co-chair of the Commonwealth Quarry Coalition, which was the statewide coalition that was responsible for helping pass the 2010 quarry reform legislation. And so in that capacity, I worked with over 135 organizations, labor groups, community, youth, faith organizations across the state on the issue of quarry. So I'm very happy to be here and to see the attention that's been given to this issue. I'm not going to go on too long because I think Hakeem and Lisa have already really covered the issues that I was concerned about. But I did just want to say a few things. I really would encourage, just to put it out there from the beginning, I think there's the timeline for us to really understand and wrap our heads around what the regulations are saying and also what's required by law has been short. And so from our standpoint, it would just be beneficial for the state as a whole to have some more time to process this information. And actually, I would really ask to see if the commission would be able to help draft documents and some information that could really help simplify the regulations so that an everyday person can understand what they're saying, and also to give us some time so that, as Lisa mentioned, perhaps later in January, we can have another opportunity where people and stakeholders can come and speak to this issue. So just from more of a transparency and process standpoint, I would just encourage you, if possible, to give communities more time and try to, as much as possible, make this information available. That's the first thing. Beyond that, I did want to just speak a little bit to the issue of this notion of sort of automatic disqualification and sort of what crimes fall under that category, and then also the discretion that the commission will have in reviewing those who are the third level tiers, those who are not licensed but are trying to get registered. To be honest, after you were doing your comments earlier in the morning, it sort of changed my understanding of what the regulations were saying. So now I'm finding a little trouble to sort of speak precisely onto what my concerns are, because I'm not sure if I've interpreted the regulations incorrectly.
Let me just interrupt here for 1 sec, because this may be helpful.
Yeah.
The rest of the process here is on these regs is what? Explain to everybody what the next
Yeah,
steps are.
that'd be great, thank you.
At some point, whether it's today or next week or next month, the commission will have to vote to approve the final language. Now, with the understanding that regulations can be amended at any point if they need to be changed, but essentially, the commission will have to vote on the final version of the regulations. There will be an accompanying small business impact statement that doesn't really affect what you're talking about, but that will have to be filed with the Secretary of State's office. And when that's done, the regulations become effective 2 weeks after that filing. At that point, obviously, the applications will become official, and we'll start looking at those and make those public. But
So there's no more public hearings at the moment scheduled?
none required, but certainly
And
it's
none
up
scheduled.
None scheduled,
Right.
and it's up to the commission to decide kind of when the end date is.
Right. Well, since Mr. Tanaka is candid enough to say right at the moment he's not exactly sure what the regs say and where the issues are, rather than do this in public, what I would like to suggest, if you'd be willing, would be to have you talk with Todd or others and make sure that you see exactly where we are and give us what feedback you've got. And if it looks like there are significant unresolved issues that we need more people to weigh in on, then we'll think about doing that.
I would be happy to do that, and my sense is that, there seemed to be a reinterpretation of some of these regulations just this morning, so my assumption is that everybody is sort of like recalibrating their understanding.
Yes,
of what they're
absolutely
saying.
true. That's what this is about.
Yeah,
Exactly. These are draft and these are discussions.
That's
and
right. I would be happy and would appreciate the opportunity
All right.
to
That would be
communicate.
great.
If I could just briefly share a couple thoughts that are more broad.
Yep.
So, one thing that I wanted to share is just to offer the model sort of hiring standards that have been established in the city of Boston and have been replicated in Cambridge and Worcester. We have all passed Corey ordinances, and in those circumstances, just from a philosophical or ideological standpoint, those cities do not require Corey checks for positions that are not sensitive in nature. So not only do they say, not only do they not sort of say this allows you to be hired, this does not allow you to be hired. If you don't have a sensitive position, then actually the city says we're not going to do a Corey check, period. So I just want to contrast that model to what's being spoken about here. I understand that obviously a casino is a different situation, but in a lot of ways the question is, and this speaks to the very question of the requirement of registration in Corey checks, as Lisa was speaking about earlier. Again, I'm speaking about the registrations, not the licensing positions, right? And in those circumstances, I again would submit that I think it's in the interest of inclusivity as far as the workforce to not have requirements around Corey per se, particularly around things that would automatically disqualify people for those types of positions. I do think that it makes sense for people to have query checks, or I'm sure that's going to happen either way, but sort of saying across the board, for example, that having a felony would presumptively prevent someone from getting that job, even if there is space for discretion, I think is problematic. That I would just really encourage you to rethink sort of that piece. And again, I recognize that I don't know what the statute actually requires, and so from that standpoint, I would be curious to understand a little bit more finely what the requirements of that are. Also, I would just...
That's why it's important.
Yep. And also, I would just, I would echo the concern around the fees. I think that's, I mean, honestly, I don't think, I don't know what other states do and how typical this is. It sounds like it is fairly typical, but I would encourage the commission to consider not having fees for working class workers. These are not people who are going to be making a lot of money, even if you allow them to spread it across a few paychecks. $75, $300 for working class people, you know, is a difference between a couple weeks of food. And so that's a real consideration. I would encourage you as much as possible, assuming that the finances allow this to bear out, that you just remove the fees altogether. So I'll leave it at that. I'll definitely appreciate the opportunity to speak more with the staff. I appreciate all the hard thinking work that's gone into it this far.
You mentioned the quarry ordinances in Boston, Cambridge, and Worcester. Are those for municipal hires?
They're for municipal hires as well as actually for vendors of the city. So in the city of Boston, the several thousand vendors for their own positions, if they're not sensitive jobs, then they actually do not do query checks. In fact, they're not supposed to do query checks in those circumstances. Right.
Thank you.
Thank you very
Thank you
much.
so much.
Maybe you can you guys can exchange cards before you go. Bill Messner. Another visitor from Western Mass.
Thank you very much. Good morning.
Welcome.
Good to see
Morning.
the members of the commission again.
Morning.
Appreciate the opportunity to offer testimony relative to the draft regulations on licensure. You may be aware that we provided specific recommendations on December 5th, which you may have had an opportunity to look at.
We have all of that. It's right here.
This morning, just like to highlight certain items in that input that we provided you with. We appreciate very much the hard work that the commission has done, particularly in the area of licensure and workforce. Particularly appreciative of Commissioner Stebbins and the interest and time he's put in to working with our consortium. Jill Griffin, David Acosta, members of your staff have been wonderful to work with. Insofar as the draft regulations that have been put forth, we would respectfully suggest that there are two areas that we are recommending further development needs to be put into. Those two areas grow out of Chapter 23K, which state that the commission shall promulgate regulations that all gaming establishment employees be properly trained in their respective professions, and go on to state that the commission may establish certification procedures for any training schools. We would recommend that growing out of both that statement that the commission has a requirement to see to the proper training of all employees within the casinos, and that you may establish certification procedures for training schools, that in fact specifics need to be built into the regulations regarding the certification for training schools. We believe that to be the case, number one, because of the emphasis that this commission has put upon the integrity of the gaming industry in Massachusetts. We would further suggest that the history of the casino industry in this country and of the training for that industry in this country would suggest that there have been abuses by training providers that have been widespread, abuses that we've seen even within the last several months right here in the state of Massachusetts, and that without those requirements, the integrity of the gaming industry and the integrity of the training upon which that industry, at least in part, will be predicated is going to be called into question. And so we've given you in our written testimony the specific recommendations in that regard. The specifics of those recommendations, candidly, are less important than our firm belief that some requirements need to be made for training institutions. And if they are not made, we're going to see the same kinds of abuses here in Massachusetts that other states have seen. Similarly, the requirement that the commission see to the proper training of all employees, number one, is predicated on the quality and integrity of the training providers. Further reason for stipulating specifics in terms of who can do that training. We have also provided you with recommendations in terms of the specifics of that training. Now, there will be some who will suggest, well, shouldn't we leave the specifics of the training to the employers themselves? And we certainly recognize that a large share of the specifics of the training need to be driven by the employer. And in fact, our consortium has been working for over a year with all of the potential casino developers in terms of developing job specifics, and we will continue to work with them. But based on precedent from other states, as well as, again, the emphasis that this commission has placed on the integrity of the gaming enterprise, we believe that there are elements of that training that may well not be emphasized or even touched upon by the casino employers themselves. In particular, areas such as problem gaming, areas such as ethical behavior, areas such as knowledge of the Massachusetts gaming law, we believe should be required as part of the training of all casino employees. And we don't believe it should be left up to the casinos themselves to see to it that that training is provided. So again, we've given you some specific suggestions along those lines. The specifics, again, are less important than the specific point that we believe training requirements need to be made part of these regulations. Let me simply close by saying, irrespective of what your determination is along these lines, we will continue to enthusiastically work with the commission and your staff in terms of providing a quality workforce for this new industry.
Great. Thank you, Mr.
Thank you
Messner.
very much.
Thank you.
Commissioner Stebbins, you've probably been wrestling with this issue. Do you want to bring to us a recommendation of where you come down on this, or have you already sort of got a position, or?
I'd be happy to. I think I wanted, one of the specific points that President Messner raises, and it's one we've talked about before, but it's raised its head recently, is over the conduct of these individual private schools that seem to pop up, and we are wrestling just as much as you alluded to with DPL over how to license these schools. We actually had a meeting over there the other day that we had to reschedule because a couple of the key people from the DPL side weren't there. So it's not something we've lost track of, and it's something that we know we want to protect the consumer, and I think to your broader point, we want to get back to making sure that, we follow the statute and making sure everybody on the gaming floor is properly trained. And certainly course requirements, curriculum requirements are relatively consistent across other jurisdictions, and they are requirements that both operators and regulators have all signed off on. So that's the direction we continue to work towards.
Yeah, and this is an issue that we've been talking about this off and on for many months, I think, this is of our role in this. And if you'd be willing to just sort of take this on as a project, these particular suggestions, and tee it up for us whenever you can.
Happy to do that.
We'll take that under consideration again. Thank you very much.
Thank you.
And last on our sign-up sheet is, I think it's Bill Kelly. Welcome.
Good morning. Good morning,
Morning.
Mr. Chairman,
Morning.
members of the
Morning.
commission. My name is Bill Kelly, and I am now the president of the Beer Distributors of Massachusetts Incorporated. The remarks I'm going to share with you this morning, I sent by email for ease of reference, but I was late and that just went out this morning. So it should be waiting for you back at the office. The Beer Distributors of Massachusetts, Inc. is the leading trade association advocating in Massachusetts on behalf of family-owned businesses in the beer distribution industry, in working to promote the responsible use of its alcoholic beverage products. The beer distributors also represent distributors in Massachusetts that are second, third, and even fourth generation family-owned businesses that employ over 2,200 people in the Commonwealth. The members of the Beer Distributors Association offer union jobs and are active participants in community activities as well as charitable endeavors. As the trade association representing 12 beer distribution companies across Massachusetts, the Beer Distributors the association serves as a resource to policymakers and the public on alcohol regulation and educational programs designed to combat underage drinking and drunk driving. Each member of the Beer Distributors Association is licensed by both the federal government and the Commonwealth of Massachusetts to engage in the distribution, importation, storage, sale, and transportation of alcoholic beverages. Each member currently holds a lawful permission from the Federal Alcohol and Tobacco Tax and Trade Bureau, commonly referred to as the TTB, who has a website at ttb.org, as well as that is an agency within the United States Department of the Treasury. And they also hold a lawful permission from the Alcoholic Beverages Control Commission here in Massachusetts, the ABCC, whose website is at mass.gov/ABCC. The Beer Distributors Association understands the Commission's general purpose of requiring the registration of any vendor of alcoholic beverages to a gaming licensee within the jurisdiction of this Commission. Yet the association is concerned about an administrative process that might be duplicative of at least two prior administrative processes. One, an agency of the federal government, the TTB, and the second, an agency of the Commonwealth, the ABCC. The concern is that a third duplicative government process would be a barrier to business, impede the orderly conduct of business, and negatively impact the performance, growth, and success of both the distributor and the gaming licensee within the jurisdiction of this commission. Now, I understand and I heard this morning that in fact there is a proposal to create a process by which a vendor could petition for exemption from registration, and that is a good development. In the BDM, the Beer Distributors of Massachusetts, welcome the opportunity to work with the commission members and the commission staff to develop and further devise an alternative to eliminate any duplication of government processes. The Beer Distributors Association is grateful for the time already given to us by the Commission's Director of Licensing, its licensing supervisor, and its Deputy General Counsel. There are a number of options the members of the beer distributors have considered to avoid that unnecessary duplication. One option would be to insert language that created a provision that any person who is required to hold, and in fact does hold, a license or other permission from both the federal government and the state government here in Massachusetts to engage in the business of offering or selling products, and specifically alcoholic beverages, to a gaming licensee shall be registered as a non-gaming vendor. A second option would be to increase the volume of business required to be done in alcoholic beverage sales before the commission exercised its discretion to require more than a vendor registration and to require the next level of more formal licensing. I thank the commission and its staff for the opportunity to provide comments on the draft regulations. And on behalf of the Beer Distributors of Massachusetts and its members and over 2,000 employees, thank you for your attention to these matters and my comments.
Thank you very much, Mr. Kelly.
Thank you.
Thank you.
I'm very much in favor of not having the folks have to do multiple things, the same thing multiple times. Obviously, the background checks aren't necessarily the same, I understand that. But as a matter, I'm sure everybody here would agree on this, and we've talked about it, that if it is possible to either use other people's certifications or to swap our certification for other people's certifications, if ours are the more rigorous or whatever, but anything that we can do to minimize, eliminate duplication of effort and streamline these kinds of regulatory hurdles for folks, particularly smaller businesses, it's a really high priority. I think we all agree with that. I'm sure you do too. So, and if they have suggestions that are good ones, let's try very hard to accommodate them.
Yeah, I haven't looked at this particular section lately, but the statute specifically mentions the ABCC and coordination of certain things, so we should really look at that.
Right, right. Thank you. Any other comments, questions, anything on licensing?
No, I think, are we finished the speakers? I just have one brief comment, and that was about the regulations that we're taking, the hearing regulations that we're taking out of Section 1 and putting in Section 134. I understand why we're doing that. My question really was a collateral question, and that is, we have a number of hearings that we hold for racing employees, for example. We'll have a number of others. We need someplace provisions for those. And I quickly checked back in Section 101, and we never had them. We only had them for these. So I agree with moving these, but at some point, I think we need to look at another set of regulations that will deal with other things that could happen before the Bureau and before hearing examiners and the like. But this is not now the time to go into the details of those. I just think we need to put that on the agenda.
I agree.
Anything else?
Well, just yesterday, we also heard from the Minority Council and others on this topic of waiver of fees, which of course we heard comments from today. I believe we could give ourselves the flexibility by inserting in the regulations the possibility of a waiver at the discretion of either the Bureau, the licensing division, or even the commission, even if it's a temporary waiver. So we could. I think we should look at that. On the flip side, I think it's very important that we apportion the costs, because we are spending a significant amount of money on the infrastructure for licensing. So it's something that we have to continue to monitor and think carefully about.
I would like to, I don't disagree with that at all, but I was thinking as we were talking about that we really should think some more about that, because if this is going to be an employer pay, at least a system, or at least an employer fronting the money system, for those at least who are successful in getting licenses, might we think about not charging the fee and just having that go into our operating expenses? I recognize that there's a difference, because
You're talking about the 75.
there's 75 and the 300.
Yeah, right.
I recognize there's a difference between an employer fronting the money and then getting it back over time, and the employer not paying anything where the license isn't granted. But maybe we ought to think about how much the employers ought to collectively share in that part of our operations, rather than having it fall on the employees. and maybe use that as a way of lowering the tax, if you will, that it takes to become employed. I don't disagree that we've got to find the money someplace.
Right.
And I don't know how to allocate that, and I don't even know if it's a good idea, but I think we ought to talk about it.
All right, I agree.
Did you have an additional question about coming to us with a letter in hand or a confirmation of employment prior to licensing?
That is an issue that has come up before. It remains in place, and perhaps that's something the commission should discuss, whether it's now or prior to approving these regulations. We did.
The regulation requires a letter from an employer saying, I'll hire you if you get a license.
Right.
It's a good idea, isn't it?
I think,
What's the counter?
well, I was just going to say, in the interest of time, there are several issues. I think for the most part, we've pretty much agreed with all the changes that you've made. There are a handful of issues, a lot of it having to do with the hiring of the low-end positions, the low-paid positions, but others as well that we've asked you to go back on. I'm wondering whether we can put this on the agenda one more time.
I think that
And we can deal with this issue then, and then we can get your feedback on these 6 or 8 issues that we've raised, and try to have that be the last shot. And in the meantime, you can talk to some of the folks who have talked to us to see whether or not there are more perspectives that we need to hear from. And if so, we can add that to the mix. If they can get it directly to you, then that will do it as well.
Are we under any time constraints here? And if so, what are they? I mean, I know we have to publish and then it's 2 weeks, but do we need to have these in place by a drop-dead date, as it were?
We were definitely trying to have these in place so we could begin licensing before there was a award of a gaming license.
Right.
So we had now the commission is looking like it's going to have to postpone that, so I think we have just some additional time.
It's not going to be till the end of February or 1st of March probably at this point, right?
The
No, the regulations have to be effective before the first part of March.
Well, if we had another meeting in, say, the early part of January, and that was the final meeting, we could, depending on what the Secretary of State's 2-week schedule is, we could get them out by probably effective by the end of February, by the beginning of February sometime.
That's right. The next publication date is next Friday.
Right.
So I don't have my calendar in front of me, but
Right.
it works from there every 2 weeks.
Every 2 weeks.
So
Right.
if the commission could approve it a day or two before every other Friday,
Right.
then that's what we're working on.
Right.
So
Let's find a place to do that.
if we could target the early meeting in January, then
Right.
Right.
then
I
that
think
would
give
take
us
care of
all
it.
a chance to do one more crack at this, yeah.
Right.
And if in the meantime, we could also prepare a quick reference guide. I take the comment from one of the speakers as very important, because it's easy to get into the weeds, because we have been,
Are
a
you
quick
talking-
reference of the regulations, just what they
In
know.
plain language.
Yes,
Yeah,
plain
that- I-
language, quick reference guide.
I do too. Somebody,
Summary.
like Mr. Cunningham or Mr. Tanaka, somebody, I think that'd be a great idea.
Yes.
So a handbook for employment with casino operators or casino establishments that puts this into simple language. That'd be a really good idea.
We had anticipated, and Mayor had discussions with some of our stakeholders about a communication plan once the regulations are adopted, then be able to bring forward the information as to what the requirements really are.
That'd be great.
Great.
Do I have a motion to adjourn the public hearing?
Yes, with congratulations to I think we already did that, but this is really,
Yeah.
really
Good work.
great effort.
Great
So
work.
I so moved.
All in
Second.
favor? Aye.
Aye.
All right. Thank you, folks.